on a very cold morning. Um, but at least I have water here at my house, which I know many of you do not. Although my dogs are disappointing me, they're on the floor, not up next to me, keeping me warm. But other than that, things are going well. Um, Very unusual session this year. I was telling somebody recently, this is my 26th session, and I've never known them to miss even a day, much less 3 days. So it's going to be strange. And last I heard, they're still planning to adjourn on the same day, which sounds like a nightmare to me. I hope they don't do that. But right now, it's all rumors, but we'll see. So, what we're going to do for you is just run through our legislative agenda. Now, we cover many, many, many issues. We have 14 people who advocate over at the General Assembly on many different issues. If we don't happen to mention an issue you're interested in, it's not because we don't care about it or that we're not going to necessarily work on it, but we just can't talk about every single issue. Feel free to ask questions. I probably work best if you put your questions in the chat, and then Maura will let me know. But we're also going to do something a little bit different we've done in the past. Is instead of listening to me drone on the whole time, I'm going to toss it around to the experts to talk about it when we get to their slide. So, Maura, if you would advance the slides. So these, okay, go ahead. That's all right. Keep going. That's all right. These are just the folks that many of whom are going to be on the call and work on different issues. Go ahead, Maura. Go ahead and advance it. Okay, safe and affordable housing. So we have 3 people who work on housing issues at the General Assembly, and Christy, I think, is the leader. So Christy, do you want to take this?
Absolutely. Good morning, everybody. So we have a pretty ambitious agenda in the tenant rights and new homeowner encouragement area. So this first slide deals with some of our eviction prevention policies that we're advocating for. The first one refers to a budget amendment to increase funding for a program called the Virginia Eviction Reduction Program. This is a program through which the Department of Housing and Community Development gives funding to local and regional nonprofits that they can use any way they want to try to keep a family housed. So for example, if a family comes in and it's the end of the month and they say, I can't pay my rent next month because my car broke down and I had to pay $2,000 to get my car fixed, the VERP program can give them money before they even get a pay or quit so they can pay their rent on time. Really successful program. And then we are trying once again, we're working again with Delegate Cousins to make what we call the tenants assertion law more user-friendly. That is the law that allows tenants that are living in unhealthy or unsafe conditions to sue their landlord to force them to make the repairs that they are legally obligated to make. Right now, you have to be up to date on rent in order to file that. And so her bill would eliminate that requirement. You'd still have to pay your ongoing rent into court, but you can file and let the judge hear why you're behind on rent. Most of the time it's because you had to go pay to live in a hotel because your home wasn't safe. And then once again, we're working with Delegate Price and this year Senator Rouse to extend the time tenants have after they pay their rent late to pay rent and late fees and avoid being taken to court for eviction, extending that to 14 days. Questions?
All right, Maura, next slide, I guess.
So the first one here deals with providing some more guidance to landlords. Last year, the General Assembly made expungement of eviction cases that are dismissed automatic, but there's a 30-day waiting period before the dismissal occurs. And this bill would say, hey, landlords, you cannot deny somebody housing because they have a an eviction case that is going to be expunged, or because they have an eviction case that was filed years ago and is eligible for expungement, but they haven't, but isn't eligible for automatic expungement. So, and then we tried this last year. We're working again with Delegate Tran to bring it back, to require landlords to accept any kind of lawful payment, lawful currency, and not charge an extra convenience fee because of the type of currency you are just choosing to pay your rent with. We hear a lot from tenants who were told they have to pay their rent online through an online portal. And oh, by the way, there's a $10 convenience fee for this thing that we are making you do. So it's designed to get rid of those things. And then we're working with Delegate Cousins to try to deal with a few things that are somewhat rampant across a lot of rental housing, but we're focusing on public housing this year because the stakes are so much higher for public housing residents who either face eviction, get evicted, or are living in unhealthy conditions. So the first thing the bill does is it allows judges to waive the appeal bond in eviction cases when someone's appealing from general district to circuit court, if that person is a resident of public housing and they are indigent. In almost every other type of civil case, if the appellant is indigent, appealing from district to circuit court, the judge can waive their appeal bond. Appeal bond can be thousands of dollars because it's usually the amount of the judgment. The exception to that is when you are appealing an eviction case based on non-payment of rent. This bill would create an exception to the exception and say, well, if you're a public housing tenant, the judge can waive your appeal bond. And then we're hearing a lot about one particular public housing authority charging $100 every time they had to go respond to a maintenance request after hours. It's their legal obligation to respond to these maintenance requests. They shouldn't be charging for that. And this would just clarify that they cannot charge their low-income tenants every time something breaks and they have to go fix it and it's after 5 o'clock. Questions on that slide or comments? Okay. And I know there's a lot of housing stuff, so I'm going through it relatively quickly. I'm going to kick it to Daniel in a second to talk about manufactured homes. Real quick, we do have a budget amendment that will be filed by several members in the House and at least one member and several members in the Senate also, that would provide what we're calling development subsidies that would be available to the 5 community land trusts across Virginia. Those community land trusts, we met with them all last month, and they say they have access to down payment assistance for the new homeowners, but they're really having a hard time finding funding to buy the land, build the homes, or renovate and rehabilitate existing homes. And so because everything has gotten so much more expensive in that area since the pandemic, this would provide them with money they could use to purchase the land, to pay for other development costs, which would lower the price of the home for first-time and other homeowners and help make home ownership more accessible. Daniel, do you want to talk real quick about the manufactured home bill?
Sure. Thanks, Christy. So 2 things related to manufactured housing. Number one is last year, the General Assembly approved a fee notice disclosure that was to be placed on the front of every VRLTA lease, showing all fees and charges that were not periodic rent that the landlord was charging, and it was not incorporated into the Manufactured Home Lot Rental Act. So we are just adding that incorporation into the MHLRA so that if people are not given that fee disclosure, it is now required from the landlord when they sign a new lot lease. The second thing that we are adding into the MHLRA is a disclosure requirement at signing of a new lot lease or a renewal of a lot lease if the lot that the home sits on is located in a designated flood zone. As we saw in the aftermath of Hurricane Helene, flooding is increasing here in the Commonwealth of Virginia, and our concern is if a park owner has been informed that a part of or all of the park is in a flood zone. That doesn't necessarily mean that their tenants are aware their home is in that flood zone, as they are not the landowners. And while there are public access searches available through the state, that doesn't mean that all residents have access to the internet or a computer or even a means of knowing that they live in a flood zone. And we're concerned with insurance denials related to a lack of disclosure of your home being in a flood zone. So we just want to make sure that residents are informed so that when they get their homeowner's insurance, there is no risk of denial of coverage due to flooding because they failed to disclose to their insurance company that they live in a flood zone. The good news is industry standards have changed. So for new home purchases, lenders and inspectors are present when new homes are put into parks. But for most of our people, they're not buying brand new and having them put into a park. They're buying on the secondhand marketplace, which means the home is older and the previous owner doesn't know, so they're definitely not going to tell the new owner. And that's it. Any questions about that?
Okay, let's go to the next slide. Okay, not sure who's on the, is there somebody on the call that can take these?
Hey Jay, this is Emily. I'm here.
Okay, great, thanks.
So we are working on some of the same pieces that we've worked on in past years. Expand the healthcare coverage to include all kids is Cover All Kids, which many people might be familiar with. It's a program to create a lookalike Medicaid program for low-income kids who would be eligible for Medicaid, but for their immigration status. This year, the program is being brought as a budget amendment rather than a bill. So there, I believe, should not be bills introduced on this issue, but it is being brought as a budget amendment. So we instituted under the Biden administration for the Medicaid program, keeping kids enrolled for a 12-month period. So that came into effect last January. The second item is looking to expand that. So kids ages 0 to 6 would stay enrolled in Medicaid for the entire time without interruption. One of the things we see in the Medicaid program is something called churn, which is where someone loses their insurance coverage due to, there can be a variety of reasons. They didn't get a notice. There was some, minor error happening on the bureaucratic side, or perhaps for a very short period, a parent had an increase in income, which went back down. And so kids will get onto coverage, lose coverage, get back onto coverage, lose coverage, sort of in a ongoing process. So what this is hoping to do is allow kids from 0 to 6 who have received Medicaid approval to keep that coverage for that period rather than being on and off insurance, which interrupts access to doctors, access to early health care, access to meeting benchmarks and getting those services on a continuous basis. So this is sort of seeking to extend the existing change for the 12-month continuous coverage just for the specific age population to help keep stable insurance for young children under the Medicaid program. The third item is extending a type of we currently have the ability for a hospital to do essentially an initial assessment for Medicaid and enroll people. And what this bill would do, there's sort of two different versions that are currently in existence. One is allowing for prenatal care for a wider variety of providers to do this essentially pre-enrollment process. And then the other one is looking at just extending it to federally qualified health centers. So I think we are hoping to support the federally qualified health center one just because of that the other one may be more expensive, but this is a way to make sure that people are getting access to Medicaid early, so that they're getting prenatal care. We know that sometimes just getting that initial enrollment is difficult. So getting different pathways in for people who need to meet with medical professionals earlier. And so this one is just specifically seeking to get that rather than having to go through the traditional process that you can get essentially pre-enrolled. And then you would have to apply for full enrollment and get evaluated and make sure that you're eligible. So it's just another pathway in for people so that they can get care they need sooner. Reducing bureaucratic barriers to access healthcare. There's sort of a wide variety of different pieces that we've worked on over the years. One of the ones we've been bringing for several years is sort of wonky, but when we originally implemented Medicaid, we did so as a restrictive criteria state, which means that Virginia is one of 8 states that is more difficult to get Medicaid care than the rest of the states in the country because we do not follow the SSI rules, whereas the majority of states do. So what we've been looking at doing for several years is just trying to align our program with SSI to simplify requirements, because one of the hardest things about the Medicaid program is how complex and how different categories of coverage are in Virginia. So one thing we're trying to do is enter into it's called a 1634 agreement with Social Security, so that we just apply the SSI rules. We don't have our own more complicated rules for certain categories of coverage that don't apply to others, which just creates confusion and difficulty accessing care. This doesn't actually change who's eligible in Virginia. It just reduces sort of the redundancy of having to get approved both by SSI and by Virginia Medicaid for those certain categories of coverage. Instead, we just accept SSI's decision and we automatically enroll someone. So that's something that we're hoping will happen in the future. Essentially, people may not know to apply for Medicaid. They may not get the notices. They may not resubmit paperwork properly. So all of the people who receive SSI are currently eligible, but unlike all the others, 38 or so other states, we don't automatically enroll people. So this is just seeking to have us do so. And then the final one is also a budget amendment related to emergency Medicaid, which is Medicaid coverage for individuals who would be eligible for Medicaid, but for their immigration status. And so that is limited to emergent situations. Unfortunately, in Virginia, we do not specifically include cancer treatment in that, despite the fact that emergencies under federal regulation relate to issues related to your organs. And obviously, cancer is one of the largest complications for people's skin, bones, organs in general. So we're just seeking to clarify that cancer should be considered emergency Medicaid treatment under federal law, which brings in federal funds to support services that people are already receiving here in Virginia. Just clarifying that that is considered emergency Medicaid here in Virginia. Next slide. Healthy school meals for all. This has been brought for several years. Our goal is to have all school meals for all children be free here in Virginia. It helps avoid stigma for individuals who are receiving assistance with meals, and also the way that the system is set up, that there's a sliding scale for schools depending on the percentage of children in which economic situation, which does mean that some schools that still struggle to feed children can have a hard time accessing some of the federal programs. So having free school meals for all children helps get rid of that stigma, and also just levels so all schools are able to get this assistance. This year, there was a decision to focus on breakfast. And so it's not going to be both lunch and breakfast, but breakfast for this year's item. And part of that is that, it's been shown that that is something that helps with truancy. It helps get kids into school. It helps make sure that they start the day off with food. And so that's going to be the focus this year. And then hopefully, if that passes, we can move on to include lunch as well. And so, and also, obviously on the financial considerations, breakfast is a less expensive option to move forward with first. And so that's also another reason why we're trying to sort of incrementally get this program here in Virginia. Another item we've been working on for several years is increasing the minimum benefit for SNAP. If somebody is eligible for SNAP, there's a minimum amount of money that you get per month. This is not my area, so I'm going to say the amount, but I would have to double check it, but I believe it's around $23 a month that you get. And obviously, with the increase in cost of food, the increase in sort of all costs under inflation, $23 a month does not go very far. And so the goal is to add a $50 increase to the minimum amount. So if somebody is below the 23 plus 50, they would be raised up to that total. So it's not to give every single beneficiary an additional amount of money, it's to increase the very bottom amount. That we are also in support of tax credits that are going to help lift children out of poverty. And we have for several years, in addition to other centers here at VPLC, been working on access to services for non-English speaking families. There's been funding in the budget in the past several years to try to get our programs up to date. For example, some of the programs we look online and somebody for a public benefit program has to meet all of the rules written out in the manuals, but the manuals are only available in English. And so there's some pretty basic. So it's this specific request is to increase the very minimum. So not all people getting an additional amount on this specific budget amendment. And then, sorry, back to the services for non-English speaking families. So I know that there's been work across various centers here at VPLC on trying to get those funding in to make sure that we are having, federally required and just necessary information provided in different languages. And then the final item is specific to Medicaid appeals, and we are looking at a budget amendment to increase the appeal time for people who are lose eligibility for Medicaid. People may be aware, but there are large delays in mailing currently that are affecting access to getting notices, to getting things timely, to being able to send your information in time. And Virginia is one of the states that has a very short appeal timeline. We only have 30 days. The federally allowed amount is 90 days. So we're looking to extend it to 90 days to deal with the fact that Virginia is one of the 10 worst states on mail delays in the country. So we're hoping that we'll get in place so that these delays do not negatively impact the people trying to get access to benefits, and that they're able to get the appeal, and even if they didn't get the initial benefit, get everything backdated to the original date so that they have full coverage. Next slide.
Okay.
Hey, Jay and everyone. I can take over here. So my name is
Thanks.
Sushila, and I work on domestic and sexual violence issues for Virginia Poverty Law Center. So as often is the case, we're trying to make improvements in the protective order statutes. So just a couple of things, because what is written here is a little bit, it doesn't really reflect what I'll be working on and what the bills are that are coming up. So one of the issues we've been trying to address is juveniles applying for protective orders and getting bounced from one general district court to juvenile domestic relations court, and trying to figure out a way to actually hold the hearing. This is whether a juvenile is asking for the protective order or the alleged abuser against whom the protective order would be issued. So I'm hoping we can work with, I noticed a bill from Delegate Keys-Gamarra about referring juveniles to other types of services, juvenile respondents. So I think that might be a vehicle to address this issue and have the hearing scheduled. The other issue is about the family abuse protective order. In it, there is catch-all relief for sort of creative solutions to what that particular problem is, what the abuse is in that particular situation between the victim or petitioner and the alleged abuser or respondent. So the way the protective order statute is written now, it leads judges to believe that the only type of financial relief they can grant is child support. So to clarify that you can provide other financial relief in addition to child support. And then the final issue, which is tricky, is about covering dating violence or true intimate partner violence and having those protective orders heard in juvenile and domestic relations court, where the judges are used to and understand those dynamics, instead of being heard in open court in general district court. So that's kind of one of the bills. There is a bill from Delegate Arnold that might address that. I think it's probably too broad-based at this point, the way it's currently written, but hopefully that's a vehicle to address these issues as well. And then, as Emily mentioned, there are many of us who work on language access issues for our clients. So there are efforts that we engage in with other agencies, other nonprofits like Voices for Children and the Commonwealth Institute to help ensure that state agencies have language access for people for whom English is not their native tongue. So I think I'll stop there and let Valerie take over.
I think we need the next slide, right?
Yes, please. Hey, I'm Valerie, and I work on family law and child welfare issues. And there are actually a lot of them this year, as there always are. But these are the ones that are our priorities. And the first one is to keep families together through legal support. And last year, the General Assembly passed a bill that codifies the practice of what's sometimes called kinship diversion or alternate living arrangements or safety plan agreements. And in those situations, the bill as passed says that parents have a right or need to be notified that they have a right to seek legal counsel before they sign any agreement that would limit their parental rights or cause the child to live with another person or anything like that. So unfortunately, the bill as passed last year did not provide for a way for people to get that legal representation. And we did have a provision in another bill and a budget amendment, but none of those things passed. So we're trying again this year. This would just be a budget amendment. It's being carried in the House by Delegate Reed and the Senate by Senator Boysko. And it would provide funds to create a pilot program to provide what is known sometimes as pre-petition legal advocacy or preventive legal advocacy. And the idea is that if a parent is facing an investigation from CPS or is being asked to sign some kind of agreement that would place the child in another home or limit their rights to visit their child or anything like that, that they would be able to contact an attorney and get some legal advice and guidance. If the reason why this is happening to the parent is based on some other legal matter, which often happens, for instance, if they're being evicted or if they've been denied certain kinds of services or benefits, then the attorney can help address whatever those issues are, which often is a case. Some of the cases that we've seen that relate to families being evicted and the children end up in foster care or in some other living arrangement. So this allows the attorney to sort of address what other ancillary issues there might be for this family. And there was a pilot a number of years ago in Virginia and Washington County, and that was done through Southwest Virginia Legal Aid. None of those children entered foster care, and in states where they have done this, so for instance, Iowa Legal Aid implemented a pilot, and they found that for every dollar that was spent on the program, the state saved $4 because foster care is very expensive. So we're hoping that this pilot will show the same kinds of things, that it will help families to become more stable and safe, while also reducing the need for children to enter foster care and thus reduce the amount of money, because Virginia spends about $350 million every year on foster care for about 5,000 children. The other thing is VPLC for a long time has worked with Voices for Virginia's Children to do advocacy workshops with youth who are in the Great Expectations program, which is a community college program to help support foster youth as they enter into college. And a number of bills that we have supported or asked legislators to carry have come from the youth in that program who have come up with ideas for legislation that they think would improve foster care. And this is one of those bills. This past year, youth from community college in Southwest Virginia said that they would like to see an office that would have oversight over the agencies that have children in foster care. And I said, oh, well, how would that be different from the Office of the Children's Ombudsman, which has that kind of oversight? And they said they had never heard of the Office of the Children's Ombudsman and did not know that it existed and did not know they had the option to contact the Office of the Children's Ombudsman, something they didn't know it existed. So this is a very small bill. It's being carried in the House by Delegate Sullivan and in the Senate by Senator Salim. And all it does is adds to the list of people who are to be informed, which currently right now is people like parents and foster parents and some other people, of the existence of the Office of the Children's Ombudsman and how to contact it. That right begins when the child either enters foster care at age 12 or turns 12 while in foster care. And they need to be re-notified annually, because the youth said that when they come into foster care, it is so overwhelming that a lot of times they forget half of the things they're told. So they want to be reminded of the existence. And then the other thing is that currently, if a youth does contact the Office of the Children's Ombudsman, there's no provision for confidentiality, which means that the office would have to get permission of the department that has custody of them to speak to the child, which obviously doesn't make the child more safe and opens them up to the possibility of retaliation for making their complaint. So this bill requires that, or allows for the Office of the Children's Ombudsman to confidentially meet with the youth. And there actually was some pushback from departments of social services. And we reminded them that if the child was at risk, there are other provisions in the code that would require the department to notify, or require the office to notify the department with custody of the child that the child was at risk. So that seems to have ameliorated their concerns. So we don't anticipate there will be any pushback on this bill. And we're very excited about it. There's a lot of other legislation that has come out of the Commission on Youth this year, and from other legislators, including one to expand the circumstances under which a parent might have their parental rights restored. So we're still analyzing those, but it looks like it'll be a busy session. Thanks.
All right, thank you. Let's go to the next slide, Mara, please. So is Joanna, are you on the call? No?
Yes.
Okay, go.
So we're looking at opportunities to continue to ensure that Virginia has the most robust unemployment insurance system possible. And one of the initiatives that we are supporting is to increase the unemployment insurance weekly benefit amount. Right now, workers receive as little as $60 per week in UI compensation and no more than $378 per week. These amounts have not been adjusted since 2012 when they went, and then they went into effect in 2014. And JLARC did a review of our UI system and found that our UI amounts were too low to cover even half of a laid off worker's basic necessities. And the idea is that UI benefits should temporarily replace enough of the worker's prior wages to alleviate hardship, but our UI benefits are not doing that at this time. There's a bill that will increase the weekly benefit amount for all workers across the board by $100. So the lowest benefit amount would be $160, and the maximum benefit amount would be $478. And that will go a long way towards starting to get Virginia where we need to be in supporting unemployed workers. That bill also has a companion study that would find a way to, in the future, automatically adjust the weekly benefit amounts as wages increase. So that's a twofold effort to make sure that UI benefits provide meaningful support to workers when they are looking for new jobs. a companion to that is an effort to increase what's called the income disregard. Right now, if unemployed workers take on part-time jobs, or if someone is working full-time but their hours are reduced to such an extent that they're eligible for UI, those workers can only earn $50 a week from their part-time work before their UI benefits are reduced on a dollar-for-dollar basis. That $50 carve out of earnings that don't reduce UI is the income disregard. So there's a bill that would increase the amount that a worker can earn before their UI benefits are cut. And that right now the bill proposes to protect the first $100 that a worker earns while they're receiving their UI. And this is a powerful work incentive that allows workers to supplement their UI benefits as they take on part-time work and try out new workplaces while they're looking for their next full-time opportunity. And especially because our benefit amounts are low, this ability to empower workers to who are resourceful to go ahead and earn a little bit more so that they can try to make ends meet is really important. So those are a couple of key initiatives. And there's also an effort to see if folks who are unemployed and have dependents, so who are caregivers, could receive an additional weekly supplement to their benefit amount. And the proposal is $25 a week for up to 3 dependents. Right now, the definition of those dependents is children under the age who are 16 or under. So there's work to be done to see if we can make that policy inclusive and as expansive as it could be to help all kinds of families. But the intent is to acknowledge that workers who have dependents and their families have additional financial hardship when they're going through a period of unemployment. So the effort is to reduce the hardship that they're facing. And those are the key unemployment insurance measures we'll be watching, as we also pay attention to others that we're so in support of that would provide uniform length of benefits. So everyone who's receiving UI could receive 26 weeks, which is the maximum of benefits, instead of right now we have a system where some folks only receive 12 weeks of UI benefits. So stay tuned for more as the session progresses. Next slide.
Okay, so I guess Dana, do you want to take this, or Carmen? You don't mind?
Yeah. Hi, everybody. Dana Wiggins, Center for Economic Justice. So we don't have a lot of proactive bills because there are so many bills related to energy. And our focus is mainly to ensure that residential ratepayers and particularly low-income consumers are protected in the energy space, the utility space. So under utility fairness, one of our goals is to ensure that the bill that passed last year from Delegate Hernandez to expand access to LIHEAP year-round to make the application window year-round as opposed to just certain particular short window times of the year needs to have funding associated with it to ensure that it actually gets rolled out. So we have a budget amendment to ensure that we're expanding that access to have eligibility for that program year-round. That said, there are so many other energy bills that we're working on with lots of legislators. So from clean energy access, so access to equitable access to solar, and ensuring that we have retail access. There's bills around retail access to clean energy. There's bills around that we're working with some of the advocates on. We're also working with the Climate Equity Working Group on an energy efficiency task force that potentially is a piece of legislation. We're working on ensuring that low-income folks, particularly, but all ratepayers, their voice around affordability has a seat at the table on all of these discussions, including data center. There are so many bills around data centers, but making sure that rights are protected. There are some utilities that are talking about securitization bills with respect to passing on savings to ratepayers, but we're keeping a keen eye and working with those utilities to ensure that it actually is a savings to ratepayers and not just passing the buck on to future ratepayers over a longer period of time and increasing costs over the long haul. So we're keeping our eye out on a lot of different pieces around energy legislation. There are so many different types, but clean energy has a whole subset, and then of course ensuring that that all of the costs that are being passed on to ratepayers are actually things that should be passed on to all ratepayers, and equitable distribution and cost allocation. Then with respect to creating a fair marketplace, and I'm looking at the time, just making sure we have enough time for questions. So we're trying to stop out-of-state predatory lenders. We're working again with legislators who we worked with on the Fairness in Lending Act, particularly Senator Bagby, but potentially others, to ensure that that we are stopping out-of-state predatory lenders from evading the tenets or the parts of the Fairness in Lending Act, protecting consumers from predatory lending practices. And then putting a dent into junk fees. We're working again with other advocates, including Freedom Virginia, but and Senator Pekarsky and Delegate McClure on really trying to ensure that mandatory fees and other kinds of junk fees, if they are required, that they are disclosed to consumers and that the consumers understand the full cost of something before entering into a purchase or buying something. They actually understand all of the fees that are involved in our effort to sort of put a real dent into the junk fees that are just rampant right now.
All right, and I think there's at least one more slide, right?
Yeah, I think so. And then Jay, do you want to take these or either one?
Sure, yeah, I could take these. So protecting family finances, believe it or not, if you owe a state tax debt, they can put a lien or garnish 100% of your wages to pay that. And there's a couple of bills in now to put a stop to that and to put the same sort of limits on garnishment as any other creditor, which is basically 25% of your wages. It's a little more complicated than that, but I'll leave it at that. Now the second bullet point there is protecting a portion of family funds and bank accounts. So this is a brand new thing that we got Delegate Hernandez to put in this year. Some people, when they get sued for a debt, then they have their bank account garnished, and it's a really awful thing to have happen to somebody. It's you just suddenly learn that all the funds in your bank account are frozen, and you basically have to go to court to get the bank account unfrozen. Meanwhile, of course, you can't pay your rent and can't buy food and all that sort of thing. And so this bill would make an automatic amount of money in the account exempt from creditors. So when the bank gets the garnishment, if you have less than currently that says $5,000, we'll see what happens when it's finally passed. But if it has less than that, then the bank won't freeze your account. And we think this is extremely important. I mean, there's people are losing other exemptions they're entitled to, like if you have your wages automatically deposited, you're losing that exemption you're entitled to unless you go to court, or maybe your child support is in your bank account. That's exempt from creditors, but again, you'd probably have to go to court to claim it. And in our court system, it's pretty difficult for anybody to go to court and do that without a lawyer. And then the last one is making it easier for people to get back unclaimed property held by the state by automatically returning some of it without requiring a lengthy process. I think that's self-explanatory, and I've seen like 4 bills on this so far, so it's apparently a popular topic.
And one more, sort of in the vein of sort of protecting sort of access to justice. from the second bullet point. We also are potentially having a piece of legislation that would sort of make the Supreme Court rule that courts can allow cell phones to actually say that courts have to allow cell phones to be able to be used by people going to court, particularly because many people have the evidence that they need on their phones. They may not have access to printers and or their schedules if they have to reschedule court dates, et cetera. All of those things become much more cumbersome, and they may not have the ability to fully access their rights when they don't have access to be able to bring their cell phone with potential evidence and other necessary things with them into the court. So we have a bill that will likely be introduced that will actually say that courts have to allow cell phones to be used. Obviously, there may be rules around it, and the Supreme Court has a really great rule. We just want it to make sure that people actually have access to their phones so that they have access to their full access to justice, particularly when they don't have an attorney.
Okay, and I think that's the last slide, right, Mara? Yep, okay. So we fielded a few questions along the way, but if there's any others, feel free to put them in the chat or speak up. Okay, great. Thanks everybody for joining us, and thanks everybody at VPLC for doing a really nice job of explaining some difficult concepts. We appreciate it. Oh, Irene, there is a question from Irene. Do we expect anything on privacy? Always.
Yes, yes, there will be quite a few bills. Sorry, there will be quite a few bills on privacy. Likely certain in terms of, obviously they're typically ones that deal with children, but there will also be, we expect there to be other privacy bills. I can put more on our website with a fuller list and the delegates and senators that have them.
Somebody asked about where do we find the actual bill numbers. So some of them we don't have yet, and some of them just came up like today or yesterday. So if you're on our mailing list, then or if you check our website, we'll be posting more information there. But also feel free to email any of our advocates, including me, and we'd be happy to pass that information along to you. Can you share how people could stay involved? Yeah, getting on our mailing list is the main, our email mailing list is the main thing. And we put out action alerts, and we put out usually weekly updates about what's going on our bills. Unless am I missing something that I should be? Okay. And thank you, Tony, for putting the link in there to our legislative advocacy webpage. Okay. All right, I don't see anything else. Thanks, everybody. Appreciate it.